Well, the California Online Privacy Protection Act was entered into law approximately 8 years ago, and the original design and intent of the statute was to require online service providers, website operators, to disclose to the users and visitors of their sites what types of personal identifying information that they were collecting through a privacy policy. And the privacy policy had to be reasonably accessible to the visitor. So generally, if a website collected things like first name, last name, social security number, or other personal identifiers that could be used to identify a person online or their physical address, the website has to identify those practices through a privacy policy. The interpretation that the California Attorney General's office has taken is that there is no difference between an app and a website that one might access on their PC, and that's consistent with the position that other regulators, including the FTC, have taken. Provided that there's an internet connection between the user of the app and some kind of central server, and that data is being uploaded from the device to that server or downloaded from the server to the device. So anytime that there's that data transfer over the internet, whether it's an app on a small screen or on a person's PC, the California Attorney General's office is going to treat those the same under Cal-OPPA. Under Cal-OPPA, a provider or an operator of a website has to disclose its information collection practices when it's collecting personally identifiable information from California residents. If a company is not compliant with Cal-OPPA and is notified that it is not compliant, it has a 30-day grace period to bring itself within compliance. If that 30-day grace period expires, the California Attorney General's office can file suit for violation of the California Unfair Competition Act, 17200. They can seek penalties for each instance in which the app was downloaded by a California resident in a non-compliant way. The potential penalties that a company could face, because they depend on the number of violations, mean that a very popular app, especially in the state of California, since the statute is tied to downloads by California residents, can mean that it's much more serious for that developer.